I'll start out real quick. I want to thank everyone for attending today. This is another one of our CMFO Roundtables, and we're lucky enough to have Tom Ryan and Steve Trimbley with us to present today. And as usual, John Mooney, John Reinhardt, myself met, discussed what would make some good topics. And I believe John Reinhardt came up with both of these. Very timely topics too. So John, it's on you.
Okay. Well, it's an interesting story because I'm sure many of you out there read the comptroller's report on Palisades Park, where they beat the crap out of the town, the CFO specifically, for allowing these payouts to occur, and cites that, this is from the press release from the comptroller, that Palisades Park wasted hundreds of thousands of taxpayer dollars by ignoring legislation designed expressly to prohibit this kind of waste, and goes on to talk about all the things they did wrong. It took them 3 years to do this audit, and then they gave the town 3 days, to respond to the report, which was not enough time given the amount of information, and then they sent it to the papers. So, you know, with the comptroller's office, you know that you never want to let the facts get in the way of a good story, because they're very quick to come out and rush the story to the press and then deal with it later. Because what are they going to do? They can retract it? Nope, they've already got it out. Interestingly enough, the town of Palisades Park hired another attorney to review all their practices. And I think so far they've identified that one employee got $5,000 payout that they shouldn't have, and all the other ones were okay, which we're going to hear Steve talk about. There's a cutoff date as to when it was okay and when it's not. So after reading the story and talking to the CFO there, I realized that we do an annual payout for our public works union. And I reached out to Steve and said, hey, Steve, we're about to make this payroll. What do I do? He goes, well, if you want to break the law, go ahead with the payroll. Of which point we then we stopped the entire payout. I had Steve review it, and then I met with the union. They weren't happy, but they realized that it was the right thing to do. So with that said, Steve is going to talk about the sick leave and vacation pay. So Steve Trimbley, for those of you that do not know him, is the founding member of the law firm of Trimbley and Prusnowski, which is located in Morristown, New Jersey. Steve specializes in labor and employment law on behalf of management, representing public and private sector employees or employers in a full range of labor and employment law issues. His practice also includes commercial litigation, administrative law, occupational safety and health law, interest arbitration, police and fire disciplinary hearings, pension law disputes, appeals, wage and hour law, and EEO compliance. He is a member of the New Jersey chapter of the Federal Bar Association and regularly reports on labor and employment law developments in the Third Circuit. He is a graduate of Johns Hopkins University and the New York University School of Law. He has been recognized by the Partnership for Drug-Free New Jersey for his unwavering dedication to the substance abuse prevention community of New Jersey. He serves on the board of directors of Preferred Behavioral Health and the board of directors of Oaks Integrated Care. He is recognized by Super Lawyers and Best Lawyers in America in labor and employment law. So with that, Steve, I'm going to turn it over to you.
All right. Thank you, John, and good morning, everybody. As John pointed out, I was asked to speak to you today about the sick leave and vacation issues due to the action that was taken by the acting state comptroller, Kenneth Walsh, that, as John points out, took municipalities and counties by somewhat of a surprise. On March 2nd of 2021, Mr. Walsh issued a report pertaining to their investigation into the fiscal operations of Palisades Park, which listed an entire series of alleged fiscal improprieties that were allegedly going on there. But the finding that tended to reverberate throughout the state dealt with the annual sellback of unused sick leave, a practice or a contract provision in some cases that is not uncommon in New Jersey municipalities and counties who often implemented programs like this or agreed to programs like this as a means of discouraging sick leave abuse, and also as a means of avoiding large accumulations of unused sick leave that would later need to be cashed out at retirement, both of which are very valid and legitimate concerns for a public employer. However, citing Public Law 2010, Chapter 3, that took effect May 21 of 2010, Walsh declared that it was illegal for municipalities to buy back sick leave on an annual basis, on a semi-annual basis, or indeed any basis except at retirement, at least with respect to any employee who was hired on or after May 21 of 2010, and then only up to a cap of $15,000. Now, you're all CFOs, and I'm certain that you are probably familiar with the $15,000 cap, but many of you were taken by surprise by the declaration that annual sick leave buybacks were illegal. And obviously, as John pointed out, that created quite a stir based on what was happening in Palisades Park. That report was followed by a news article dated March 29th, 2021 by Andrew Ford of the Asbury Park Press and ProPublica. Given Mr. Ford's usual, we're being sarcastic here, calm, non-controversial, non-exaggerated writing style, he announced that 25 New Jersey municipalities had made what he called unlawful annual payments to police officers between 2017 and 2019. He identified some of those towns by name, spoke to business administrators and mayors there, talked about how they had made illegal payments, whether they knew these payments were illegal, many of whom said that they were not aware of that, and demanded to know what their plans were about recouping these payments that were made illegally, quote unquote, to police officers. He also made dark references and dark hints about taxpayer suits to recover money. Now, Ford typically focuses his reporting on police departments, but the logic of what he is saying would apply with equal force to civilians as well. Now, John pointed out that inspired many municipalities to take a look at their practices and question whether they needed to take corrective action so that they did not end up in an Andrew Ford story or being investigated by the state controller. So the question is, how did we get here? What do we do about it? And what about other forms of time off, such as vacations, personal days, and compensatory time? Well, we need to start with the basics. Sick leave, vacations, and other forms of time off are paid time off that come from one of three places: statute, collective negotiations, or policy. Statutes include, for example, the new New Jersey paid sick leave law that took effect in 2018 that requires that we permit our employees up to 40 hours of paid time off per year, unless in the case of a public employer, you are already subject to a statutory sick leave requirement. Other statutes would be the civil service statutes for those of you who are civil service employers. NJSA 11A 6-3 sets forth a minimum number of vacation days that you must afford for your permanent employees per year. That's a floor. You can negotiate up from that. NJSA 11A 6-5 mandates that permanent civil service employees receive 15 sick days a year that may accumulate without limit. In contrast, vacation days may only be accumulated 1 year only, which means that no employee should have more than 2 years of vacation time on the books in a civil service municipality. There are separate statutes providing municipal police and firefighters with up to 1 year's sick leave per illness. That's a maximum. You can negotiate a 15-day or another sick leave arrangement in negotiations. Another statutory source of paid time off is comp time under the Fair Labor Standards Act. In lieu of overtime, that's permitted in the public sector only. You have to have an agreement or policy in place in order to afford, in advance of the work, in order to afford compensatory time in lieu of sick leave. In lieu of overtime. But if you do, then that is governed by the statutory requirements under the FLSA. Second potential source of sick leave and vacation, other paid time off, is collective negotiations, which is likely the primary source in non-civil service municipalities. Absent a statute fixing vacation leave or sick leave, these are mandatorily negotiable subjects, and you have a good degree of flexibility in how to design the program and design entitlements and deal with accumulation. Again, subject to a statutory requirement that for those hired after May 21 of 2010, vacation time can only be carried over for 1 year. The third source of paid time off is employer policy. In the absence of a labor union or a preemptive statute, counties and municipalities are free to establish their own policies for paid time off, with one new exception. When the New Jersey paid sick leave law was adopted in 2018, it included a provision that prohibits counties and municipalities from adopting any new ordinance, resolution, law, rule, or regulation regarding earned sick leave. Now, it's unclear whether that applies to all sick leave or only to the minimum 40 hours that the statute requires, but that places something of a limitation on adopting new resolutions, ordinances, and rules at the municipal and county level pertaining to sick leave. Other than that, you have general flexibility to develop a sick leave or paid time off program as you see fit. Right. Now, the law and arbitrators interpreting collective bargaining agreements have historically treated vacation and sick time differently. Vacation has always been viewed as a form of deferred compensation. Once you earn it, absent a policy provision or a contract provision calling for forfeiture of time or limiting your accumulation, it is deemed to be a vested benefit that belongs to you, which means that the default position is that when you leave employment, you are entitled to cash out any accumulated unused sick time that you have, absent some express provision to the contrary. So the default position is vacation is time that you've earned and you're entitled to cash it out, all other things being equal. Sick leave, on the other hand, was treated as a contingent benefit. It is designed to provide employees with income security in case they become sick. As a result, the courts and arbitrators have said there is no automatic right to use or receive sick leave unless you actually become sick. The corollary to this is that the default position is that on termination of employment, again, absent some express provision to the contrary, the employee has no entitlement to receive payment for unused sick leave when they leave employment for any reason, which is why you would need either a specific policy or contract provision in order to entitle employees to cash out sick leave. In the absence, it's lost. Other forms of paid time off, be it bereavement, personal time, comp time under contract, fall within these two extremes. And it depends on the contract language, on your policies, and where applicable on statutes to determine whether that time can be cashed out when an employee leaves. The one exception would be compensatory time in lieu of overtime under the Fair Labor Standards Act, which as a matter of law must be cashed out in its entirety when the employee leaves employment for any reason at a rate of pay that the employee is earning at the time of termination. Other than that, for those other forms of paid time off, it's a matter of contract negotiation and of policy. Which brings us to our first polling question. And do I pose that question or do you pose it, John?
Brian will do it for you.
Okay. And the polling question is, does your municipality offer a single package of paid time off rather than traditional separate categories of sick time, vacation, and personal time? This will be primarily of interest to non-civil service municipalities. In a civil service municipality, you are required to provide those separate categories, at least of sick time and vacation. So for those of you in non-civil service municipalities in particular, this is a question of interest to you. Proceeding, in the public sector, the number of sick days far exceeds the number of sick days you see in the private sector, which is on average 5 days a year. In a civil service municipality, you're guaranteed at least 15 days, and other municipalities have followed suit. Typically anywhere from 10 to 15 days is typical in the public sector. Also unusual to the public sector is unlimited accumulation. In the private sector, the days are annual and they're lost if they're not used. In the public sector, they accumulate without limitation, often from year to year. Employees therefore have an incentive to use these days to avoid losing them, which in turn leads to sick leave abuse, which is a common problem that all municipalities and counties have had to deal with at one time or another. Employers needed ways to discourage excessive use of sick leave. One of the measures adopted to deal with this problem was the widespread practice of allowing employees to cash out all or a portion of their sick leave upon retirement. Again, this was not mandated by any civil service requirement or any other statute. This is a practice that began at the municipal level and became fairly standard practice throughout the state. Details of these policies and contract provisions varied. In some cases, they were capped at a dollar amount. Some cases, you only paid a fraction of the days, for example, 1 day for every 3 accumulated. The idea was to discourage excessive use of sick leave and reward employees for remaining employed with the employer and for their loyalty. But that was not the only program that we saw adopted. In some municipalities and counties, there was a program of buying back sick leave on an annual basis, either as a matter of policy or as part of a collective bargaining agreement. Other municipalities allowed employees to use their unused sick leave as a form of terminal leave before retirement. And some municipalities combined the two by cashing out a fraction of the unused sick leave and allowing the balance to be used as terminal leave, essentially allowing the employees to effectively cash out the entire unused allotment. Yeah. The result of this was what was perceived to be abuse and excessive burden on the taxpayer. There were numerous newspaper accounts that I'm sure you recall reporting highly compensated employees throughout the state with significantly large accumulations of sick leave receiving large cash payouts upon retirement, particularly highly compensated employees that made news throughout the state. And worse yet, in many cases, these unused banks of sick time that were cashed out on retirement were essentially unfunded liabilities that were not adequately financed, and leaving the municipality to scramble to pay for them when a long-serving, highly compensated employee retired. The response was legislation limiting the amount of sick leave that could be cashed out upon retirement. State employees had always, in the civil service system at the state level, had always faced a cash out limitation of $15,000. And the legislature sought to limit local employers to the same cap. It was thought to be reasonable that all public employees throughout the state should be subject to the same limitation. At first, this was limited to specific categories of highly compensated managerial employees. But in 2010, when the legislature adopted Public Law 2010, Chapter 3, this sick leave cap was extended to all public employees hired on or after May 21 of 2010. The statute applies to all civil service employees, non-civil service employees, and even public school employees. And the critical language, which is important to bear in mind, says the following. Political subdivisions, quote, shall not pay supplemental compensation to any officer or employee for accumulated unused sick leave in an amount excess of $15,000. Supplemental compensation shall be payable only at the time of retirement from a state-administered or locally administered retirement system based on the leave credited on the date of retirement, close quote. Now, supplemental compensation, which is a term that was used in the statute, is a critical term because it comes from the state civil service system and is a term that at the state level is used to refer to the cashing out of sick leave upon retirement, up to a cap of $15,000. There is no provision at the state level for annual buyback of sick leave, for the use of sick leave as terminal leave, or any other form of cashing out of sick leave other than supplemental compensation. The fact that that term was incorporated into Public Law 2010, Chapter 3, implies that the legislature intended the same meaning to apply at the local level. Now, when the law took effect, most of us focused on the cap, the $15,000 cap, and overlooked the rest of the statute. Maybe we didn't study it as carefully as we should have, but one agency that did look at the entire language was the Public Employment Relations Commission. In 4 decisions between 2015 and 2018, PERC held that Public Law 2010, Chapter 3, prohibited the cashing out of sick leave at any time other than retirement for anyone who was hired on or after May 20 of 2010. One case came out of Southampton, another case came out of Little Falls, third case came out of Howell Township, and the fourth came out of Atlantic City. The most relevant case for our purposes is the Little Falls case. Little Falls had a contract provision requiring the township to buy back 5 sick days per year. After the enactment of Chapter 3, Little Falls refused to apply this provision to anyone who was hired on or after May 21 of 2010. The union tried to take the case to arbitration. The employer filed a scope petition to enjoin arbitration, and PERC agreed with the employer, again emphasizing that the only time that sick leave could be cashed out was at retirement and no other point in time. Now, I mentioned that there was some lack of clarity and people didn't really focus on the contract language dealing with the time in which the only time sick leave being paid out could be at retirement, and it is perhaps understandable when we look at the sponsored statement that accompanied Chapter 3, Lisa Sennett's sponsor statement, which on the one hand made the comment that under the bill, supplemental compensation for unused sick leave cannot exceed $15,000 and, quote, can only be paid at the time the officer or employee retires, period, close quote, which tends to support PERC's conclusion. But in the next paragraph, it talks about current law limiting the $15,000 maximum amount to state employees, and there's no such limit with regard to local government, implying that the key amendment here was going to be the salary cap and not necessarily the timing of when sick leave could be cashed out. Also, the use of the term supplemental compensation was ambiguous because it implied that that only applied to the cashing out of sick leave upon retirement, but did not address the payment of sick leave at any other time. So if there was lack of clarity on your part or our part or municipalities generally, it was understandable given the ambiguity in the language and in the legislative history, or at least the apparent ambiguity. The PERC decisions I mentioned to you remain to this day the only case law authority on the cashing out of sick time at any time other than retirement. There are no court decisions on point. And Comptroller Walsh in his report on Palisades Park relied only on these PERC decisions. It is now clear, however, that in terms of labor relations, buyback provisions in labor contracts are unlawful and unenforceable. And by the logic of the PERC decisions, it's not just buyback provisions that would be unenforceable. Any other means of cashing out sick time other than the payment of cash at the time of retirement would be unlawful. This would include the terminal leave provisions or terminal leave practices I spoke about earlier. Because the statute requires sick leave to be paid, and PERC has interpreted that statute, particularly in the Howell Township Board of Education case, to require sick leave to be paid. Any other form of compensation for unused sick leave would also be unenforceable in a labor contract, which gives rise to our polling question number 2. Does your municipality buy back or cash in accrued unused sick time at any time other than retirement or allow it to be used as terminal leave?
post the results of the poll after a minute if you want to look at it and have other people see it too.
All right, well, while we're tabulating the poll results, I'll go on. The fact that the only decisions out there are PERC decisions puts us lawyers in a kind of awkward situation. PERC is limited to collective bargaining and collective negotiations issues dealing with public sector labor unions. It has no real jurisdiction over non-union employees, and its decisions are not binding on courts or in any area outside of labor relations. But unfortunately, when you study it, it looks as though PERC's analysis would appear to be correct. When you look at the plain language of the statute, which states that supplemental compensation, quote, shall be payable only at the time of retirement, close quote, it strongly suggests that the words say what they mean and mean what they say, that it can only be payable upon retirement. The legislative intent to track supplemental compensation for state employees, given that state employees cannot cash out sick leave at any other time but retirement, would also tend to reinforce the correctness of PERC's analysis. Technically, it is still an open issue outside of the union context, but it seems more likely than not that PERCs are going to agree with, or the courts are going to agree with PERC, and it should be emphasized there's no clear authority, evidence, or statutory or legislative history language that states the contrary. It is important once again to note that this limitation only applies to those hired on or after May 21, 2010, and then only to sick leave. Okay, if there is going to be a fix, unless a court decides it's going to reject plain language of the statute and reject PERC's analysis, ultimately, if there's going to be a fix, it's going to be at the legislative level. So what do we do now, given the situation in which we find ourselves? Well, number one, I don't think you have any choice but to discontinue any form of cashing out, buying back, granting terminal leave for sick leave for any person who was hired on or after May 21 of 2010. Certainly that's the case under any collective bargaining agreement, given that PERC has categorically told us that these provisions are illegal, and more likely than not, it's going to apply to others. That is the first step you're going to have to take. You're going to have to reassess your policies, your contract provisions, as John did in Wharton, and take corrective action. If the unions balk at it or grieve it, you'll need to do what they did in Little Falls and file a scope petition. The next step is to assess what you want to do and what you want to accomplish, bearing in mind that this limitation on the cashing out of sick leave was meant to benefit you and your taxpayers by eliminating a significant municipal cost. You may be happy with this result and may decide that you're going to live with what the law requires. Others may want to find some way to replace this lost source of income. So you have to give due consideration to alternatives. Again, the statute only applies to sick leave. It does not apply to other forms of paid time off, such as personal days. In a non-civil service jurisdiction in which you're not locked in to 15 sick days a year, you might want to consider, for example, a scheme of converting a certain number of sick days to personal days and buying those personal days back at the end of the year if you want to maintain that benefit for your employees. Another option to consider in a non-civil service jurisdiction is to convert your various forms of sick leave into a generic paid time off. There's no statute limiting the cashing out of paid time off. If you're going to do that, you want to consult with your municipal attorneys and your municipal labor attorneys. You're going to have to be more careful about it than one municipality I know that simply took their sick leave article and turned the word sick leave into paid time off, but otherwise left all the doctor's notes provisions and use for sick leave language in place, and very much looking and talking and acting very much like sick leave. That's not going to be effective. Again, there's no obligation for you to do this. You may be happy with the fact that you don't have to make these payments anymore. You're going to need to take into consideration what your labor relations are, what your governing body wants to achieve, and assess the situation that your municipality or county is in and how it will best serve your interest to consider or not consider alternatives. Obviously, if you're in a civil service jurisdiction, you're under greater restrictions. You really are locked into 15 sick days a year. You're locked into maximum accumulation for vacation time. So your options may be more limited. All right. The next thing you should do is be prepared to hear union demands to negotiate a replacement benefit. If the union understands that you legally can no longer pay this benefit, they may come back and request that you negotiate with them for a replacement benefit. Again, assess what your municipal needs are, assess what you're going to need to achieve, what your financial limitations are, and be prepared to have a strategy in place to respond to those types of demands. You may be confronted with a request or a question whether you intend to recoup the supposedly illegal payments that were previously made subsequent to May 21 of 2010. That is always a possibility. You might face such a demand. My suspicion is that you will likely face resistance from the courts if you attempt to do this. The argument on the one hand is that the payments were illegal and should not have been made, and therefore the municipality is entitled to recoup them. However, to the extent that your employees relied on a contract provision, on a policy that was in effect, that may be a countervailing consideration. The one case in this regard came out of Middlesex, in which at the time they were extending under contract retirement health insurance coverage to police officers who were clearly not entitled to receive it under the statutes that were in effect at the time. A taxpayer sued to recoup the money that was paid for the premiums. The state Supreme Court rejected his application, talking about the reliance interest on relying on a contract provision that had been in place in good faith. My observation, which is clearly not a piece of legal advice, just an observation, is that courts tend not to be all too sympathetic to taxpayer suits to recover payments if the municipality is not on board. So you would want to consult with municipal counsel to get an opinion whether attempting to recoup these so-called illegal payments, number one, is advisable, and number two, what the likelihood is of success. So I would certainly encourage you to get formal legal opinions before you consider taking action along those lines. A sixth consideration is the New Jersey Paid Leave Act, which was enacted obviously subsequent to Chapter 3, which contains two provisions that appear to authorize the annual buying back of sick leave. One provision, NJSA 3411D, Section 3C, if you allow your employees to accrue sick leave or earn it through the course of the year, at the end of the year, in the final month, the employer has the option to offer the employees the option to buy back 50% or 100% of the time that they accrued. If you grant the employees, as I would think most employers do, the full complement of annual sick leave at the beginning of the benefit year, a separate section, 3411D, Section 3D, tells the employer you must allow carryover or offer the employee the opportunity to cash out the full amount. Now, the argument would be that these provisions supersede Chapter 3, at least up to the mandatory 40 hours of sick leave that you're required to provide employees under the paid leave law. This is an unanswered question. As we lawyers like to say, this is going to be a question of whether the general sick leave provisions of the paid sick leave law predominate over the specific provision governing public employment and the capping out and the limitations on the cashing out of sick leave. Even if it did apply, it would be available only to non-civil service employers, because civil service employers who have a statutory obligation to provide sick leave are excluded from the coverage of the paid sick leave law, and would also, for the same reason, not be available for police or fire. This is, as I said, an unanswered question, something that you are going to need to consult with your municipal attorneys and municipal labor attorneys about whether this is a viable option or not, just something to consider. So we are in a somewhat new world when it comes to sick leave and the cashing out of sick leave. For many of you, this is going to require a change in your existing practices. It's going to make your employees not very happy, but it's something that was forced upon us, something that is part of the law, and something that appears to have been the law that we should have been following since 2010. And I've given you some options of how to deal with this and what to think about in terms of going forward. I don't know if I used up my full 50 minutes that was allotted to me. So if there are any questions, I guess we can take them now.
Steve, I have a couple questions, actually. And you stole a couple of mine with your presentation, so you're killing me. I was looking for some filler. So we know that the earned sick leave law and that other one that we're referring to, that they are in conflict, right? Because one calls for the payout and one does not.
Right. Well, one allows for payout and the other does not. Again, as I said, if you're a civil service employer, that question is moot, because the paid sick leave law excludes public employers who are under a statutory obligation to provide, already under a pre-existing statutory obligation to provide sick leave. That would include any civil service employer that by statute is obligated to provide 15 sick days a year, and it would exclude police and fire employees, because they are by statute entitled up to 1 year of sick leave per year. So even that is of limited, even if that interpretation were correct and you were allowed to cash out under the paid sick leave law, it rules out maybe half of New Jersey employers because who are in the civil service system, and also rules out police and fire. So it would be of limited utility.
I'm looking at the list of attendees, and I'm betting that we have a majority of non-civil service attendees that are here. So use me, use the Borough of Wharton. We're not civil service.
Yeah.
And now I have under the New Jersey sick leave law, the option to pay out up to 50%, right?
Right.
Does that supersede the old law? Because the new law is newer.
Well, that's one argument. A lawyer would argue that the newer law supersedes the older one, although the response is that courts disfavor implied repealers, will try to read statutes together and harmonize them to the extent that they can. And the argument would be on the other side that Chapter 3 deals specifically with public employment, deals specifically with sick leave cash out, and deals specifically with limiting to the payment being at time of retirement, whereas the paid sick leave law was general and intended to apply to all employers in the state. So it's an unsettled question. Again, that's something you need to discuss with your municipal attorney. You need to discuss the pros and cons, the risks and the benefits, and come to a decision whether to adopt that approach. The other argument would be is whether it applies to all sick leave that's accumulated or only to the minimum 40 hours that the paid sick law obligates you to provide. So there's some risks of going down that route that need to be considered.
So Steve, we have a couple questions from the attendees right now. The first one is, our PBA has asked for a perfect attendance bonus for not using sick time. Is that permitted?
I would say yes, because you're not really cashing out the sick time. You are giving them payment in addition to the sick time that they've accumulated.
Right. I think if it were me and we were granting that, I'd want to have pennies on the dollar at the final payout, so they're not even less than the 15 to make it harder to get.
Right.
The second,
or you'd want to ask for some other trade-off. Okay, you want a perfect attendance bonus? I want something else in return.
right. Next question is, our PBA has showed a provision in another town that does not pay out sick leave, but after 25 years of service will receive a sum equivalent to 6 months of pay upon retirement. Is that permitted?
I think that provision may run into trouble, not based on the sick leave statute, but as being a retirement incentive that the pension systems disapprove of. PERC has held that contract provisions, payouts that are designed to encourage people to retire sooner than they otherwise would are non-negotiable because it affects the actuarial assumptions of the pension system. So it might be problematic from that perspective. So there's a problem there as well. But you need to look at the contract language and also see how it's applied. But any sort of payment that's payable after X number of years, or that talks about a retirement after X number of years, is going to run into problems based on the concern regarding the pension system's actuarial assumptions.
So as people are asking for your opinion, do you want to do your disclaimer now that they need to seek the advice of their own paid attorney?
Yes.
Or call you or Tom?
Well, yes. This is just general information. What I'm offering here today is not legal advice, should not be taken as legal advice. And as I said throughout my presentation, any questions, any specific issues you have, discuss it with your municipal attorney, discuss it with your municipal labor attorney.
I love that I gave my own attorney advice right there. So the next question is, does it matter if annual sick leave buyback is paid as deferred comp into deferred compensation account?
Yes, it does. No, it does not matter. And yes, it is prohibited. That is what happened in the Howell Township Board of Education case. The union wanted the sick leave to be converted into a payment into a 403B account, and PERC struck it down. It was not a negotiable subject because, again, under the statute, sick leave is capped at $15,000, can only be cashed out at retirement, and must be paid in the form of cash. It cannot be used converted to deferred compensation, cannot be diverted to a 403B account, cannot be used as terminal leave.
All right, I'm just going because people are posting in both sections. Let me just see.
There's one chat question. Is the option to pay out unused sick at the policy of the employer, or is it a right of the employee?
It is a policy of the employer, unless there is a union that represents the employee, then it's something that must be negotiated. But absent a policy or a union contract calling for it, there's no absolute right to have your sick time cashed out on retirement.
The other one is coming in. Let me see if I can read this one. It says, this section shall not be construed to affect the terms in any collective negotiations agreement with a relevant provision in force on that effective date. I guess he's quoting from the law.
Yes.
How does the not construed?
What it meant was that if you had a contract in place at the time the statute took effect, which is May 21, 2010, the statute was not applicable to you until that contract expired. Now, PERC in the Howell Township Board of Education case took it one step further and said, once the contract expires, anyone who was hired on or after May 21, 2010 is subject to the limitations, even if they were hired when the contract was in place. So in other words, the effective date was retroactive once the contract expired. And it created, in the Atlantic City case, a sort of awkward situation where if you retired or you had the sick leave cashed out to you before the contract expired, even if you were hired after May 21 of 2010, you could receive the cash out until that contract expired. But once that contract expired, you were prohibited from receiving any further cash outs. So that's the meaning of that. That's how that section and sentence have been construed. That it only applies to a contract that was in effect on the date that the law took effect. Once that contract expires, The limitation applies, and it applies to anyone who was hired on or after May 21 of 2010. The reason why that provision was put in the statute is that if the legislature tried to change the terms of a contract that was already in existence, that would raise federal and state constitutional issues under the federal and state contract clause. So it had to be effective once the contract expired.
The next one was really just a comment, or here's a question. Does Steve have a handout of his comments and or important considerations to share as a guide?
Well, unfortunately, I don't have a handout. If you're interested, we can prepare one and forward it to Bud and John for distribution to attendees. As far as any pointers, I go back to what I said before. Discontinue payments except on retirement. Consider whether you are happy with that situation or whether you need to negotiate new terms and conditions or want to consider alternatives. Be prepared for the unions to demand that you negotiate over a replacement benefit and decide a strategy for dealing with that. And fourth, consult with your municipal attorneys and labor attorneys to determine what, if anything, can be done about recouping payments that you inadvertently made illegally, quote unquote.
So there's another question, but I think Steve, I'm going to say what we did with here in Wharton. When we determined that the annual payout of unused sick time was illegal, we also made the determination that anybody hired before that 2010 date, May 20th or 21st?
May 21st.
That the ones that were eligible to, were there before that date could continue to get paid out.
Yes.
So that the next question is, can you pay out sick leave to deferred comp for someone hired prior to May 21st, 2010 at retirement?
The answer is yes, because they're not covered by the limitations. And to amplify John's point, particularly if you have a collective bargaining agreement in place, the only illegality is for people hired on or after May 21, 2010. So if you're going to discontinue the benefit, you only discontinue it for them. For people hired prior to that date, the contract provisions are still enforceable. And if you nullify those provisions as it applies to those earlier hires, you will be committing an unfair labor practice. So what you discontinue is the payments to people hired on or after May 21, 2010.
Steve, is there a first in, first out basis for use of that prior time prior to May 21st? So if you earn time prior to May 21st, anytime you use after that date, you're using that older time first versus any new accumulation?
That's going to depend on your contract language and how you structure the program. In many cases, it's irrelevant because it gets cashed out at the rate you're earning at the time you retire, and that's how you ended up with these enormous payouts for the highly compensated employees. Other labor contracts say, look, it's paid at the time that you earned it, and you use the newer time first when you use your accumulated time. So this way you burn off the more expensive time and cash out the less expensive time. So again, it depends how you structured it in your contract.
So we have one more question. It says under section, I love when people quote the exact citation, 11A:6-19.1, are employees who hold licenses exempt?
What was that citation again?
11A:6-19.1. I was actually going to pull it up as well because I wanted to see what that is.
I believe that is a state. I know it's a civil service statute.
So how about we pass on that one because we've actually hit our time limit, and I would suggest that they actually consult with their own labor attorney since that one's so specific.
All right, and I apologize for not having the statute at hand.
Okay, we hit our 50 minutes. I don't see any more questions. Steve, thank you very much.
And thank you. Thank you for having me.
Anytime. Bud, did you want to say anything?
No, I was just going to thank Steve. just in case Steve leaves and doesn't stay for Tom's exciting presentation.
No, I intend to stick around because usually what Tom has to present is very much on point, and I'm very anxious to hear what he has to say about this, about the equal pay law that we're all
Feeling the pressure. I'm starting to feel the pressure.
So Tom is going to talk about the Diane B. Allen Equal Pay Act, which I know many of us saw when it came out, and we're sitting there holding our breath saying, all right, did we do our due diligence? Did we do enough work? And maybe we did, maybe we didn't. It actually forced me to do I took an area survey. I mean, you're supposed to compare internally, and Tom can correct me if I'm wrong, but I actually compared all of my licensed officers, and I compared them to the area to figure out an average. Am I underpaying or overpaying? And I actually identified one employee who was severely underpaid, and came up with a 3-year plan to bring that person up to what I thought was an equivalent pay for the area, for the market. But it's not how the law was intended, I don't believe. But for me, it was an exercise in identifying, how people were compensated, and was it appropriate. So Tom Ryan has agreed to speak today on that topic. So a little bit about Tom. Tom is the founding partner and is currently the managing partner of Laddie, Clark, and Ryan, who you will hear him call LCR. Tom is an employment and commercial litigator and a business lawyer who focuses on representing management and individuals in both the private and public sectors. He has litigated cases in both the New Jersey State Superior Courts and in federal district court. He has been long and continues to be, sorry, I can't read this. He has long been and continues to be a leader in the legal community and the business community, as well as in community service. Tom has extensive experience in employment discrimination, wrongful termination, discipline, breach of contract, harassment, wage and hour, collective bargaining, and other employment-related issues. In addition to litigating cases in the state and federal courts, he also advocates on behalf of clients in the administrative courts, before the Department of Labor, and I'm going to scoop all these acronyms. There's a whole mess of them. I'm going to pass OSHA and a bunch more. He represents clients on employment contracts, compensation agreements, non-competition and non-disclosure agreements, and severance agreements. Tom reviews and prepares personnel policies and handbooks, conducts investigations into employee complaints, provides harassment and discrimination training, and counsels clients on all employment issues. With that said, I'm going to introduce Tom Ryan.
All right, hey, thank you very much. Well, to sum up that very kind introduction, I think it just simply means I've been around for a heck of a long time. Over the decades that I've been wandering around, I've certainly been able to touch upon a lot of the issues that show up in municipal law, particularly those issues that show up in public employment and labor law, although I also have wandered into the field of the private sector as well in addressing those laws. And I must say, I thought that my presentation today might be pretty intimidating until I started listening to Steve and his very detailed and excellent review of the sick leave laws and the recent analysis provided by the Comptroller's Office. I will say, just before we leave that topic, I do think we haven't heard the last on that issue. I do think, as Steve pointed out, we haven't yet heard from the courts specifically on the point, and there are such detailed aspects to it that I suspect we're going to see something in the year or two ahead. Indeed, we're guided right now by the PERC decisions, but hey, even applying those PERC decisions, certainly as our audience was already pointing out, it still raises an awful lot of questions. So I'm going to talk about a focused topic, and that's equal pay. And it's the Diane B. Allen Equal Pay Act, not to be mistaken with another extraordinary leader in such issues, Susan B. Anthony. But many of you will recall that Diane Allen was a distinguished Republican state senator in New Jersey and was always at the forefront of equity issues and fighting discrimination during her career in the New Jersey State Senate, and even before that as a broadcaster. As was reported by, in fact, New Jersey Advanced Media back in April of 2018, New Jersey really jumped to the forefront of equal pay legislation and equal pay laws. It really cemented itself in the history books when Governor Phil Murphy signed the most sweeping equal pay legislation in the nation. And it really has remained in that #1 position. The new law protects women and minorities in the state from workplace discrimination by making it illegal to offer lower pay and benefits to them. Employers who pay one person more than another have to demonstrate how their experience and education sets them apart. Women who seek damages in court would be allowed to recoup lost wages for up to 6 years, 3 times longer than the federal law's 2-year statute. Employers are also prohibited from cutting the wages, an immediate kind of bootstrap reaction. Well, if I have to pay somebody more because it's alleged to be discriminatory, well, I'll tell you what, I'll just lower the bar for everybody. Well, this law anticipated that and specifically prohibits it. New Jersey now has the most rigorous protections against pay discrimination. And that does not rest just with the private sector. It very much applies, although not to the federal government because it's a state law, it indeed applies to municipalities, it applies to counties, it applies to other local and state public entities. So the new law we're talking about is indeed the Diane B. Allen Equal Pay Act, named after that longtime state senator. And it addresses the issue of disparity of pay. And it really assigns the responsibility for education and enforcement primarily to the New Jersey Division on Civil Rights, although issues with regard to violations of the act can also be brought in New Jersey State Superior Court. So let's spend some time going through what employers need to know, what employers need to do. And again, not just private sector employers, but also public sector employers. Now, what I've tried to do, emphasis on try, because I'm going to be dealing with sharing my screen and moving along a PowerPoint presentation. I'm going to try to present to you during this program a PowerPoint presentation. And as is indicated, the law was signed into effect by Governor Murphy and then subsequently took effect. And I should go back. It was signed into law by Governor Murphy in April of 2018, took effect the following July of 2018. It strengthened the Equal Pay Act protections of the New Jersey law against discrimination. So a lot of the elements of the equal pay law should not be new to us as employers. It really fortifies what already was in existence. And that, of course, is the NJLAD, the New Jersey Law Against Discrimination. If you're familiar with that law, and boy, I really hope you are, if you're familiar with that law, then you're going to appreciate the intricacies of the Equal Pay Act. And I believe you're going to be more comfortable in ensuring that it's applied properly in terms of all of your employees in your organization. It's been described, as I touched upon earlier, as the most sweeping equal pay legislation in the nation. So once again, good, bad, or indifferent, New Jersey is at the forefront of employment law. Now, Perhaps we haven't heard a lot about it in the last 12 to 16 months. We haven't seen a lot of enforcement of the equal pay law in the past 12 to 16 months. And I suspect that you understand why. It really indeed has taken a back seat to the states confronting and dealing with the issues of COVID-19. So you might even say, to some extent, I don't think the division would agree with me, but there's been somewhat of a pause in enforcement. This should not lull us into a false sense of security, however. And in fact, we should recognize that the enforcement of the equal pay law is going to be stepped up, and indeed is going to be a higher, increasingly higher priority in indeed this administration. And therefore, it's really good to hear John's comments in terms of how he's responded to the law. And the way to respond to this law really is to look at yourself now, to indeed conduct an internal audit of your pay practices now, and that's before a complaint is filed against you. The focus of state government will soon indeed return to enforcement. And the goal, the goal is obvious. It's to eliminate discriminatory pay practices. Now, education is going to be followed by enforcement. So that's what this morning is all about. It's really about education. And I would submit to you the Division on Civil Rights has indeed been focused on education. And what you don't get in this morning's program, in this morning's presentation, is readily available to you on the Division on Civil Rights website. In fact, much of the information that I'm going to be presenting to you and the comments that I'm going to be presenting this morning really comes from the guidance provided by the division. So I am not claiming authorship here. I'm recognizing the comprehensive work and thorough analysis that the Division on Civil Rights has been engaged with and the education that they have been involved with. So indeed, the state's objective through education is to ensure that employees know their rights. So understand that they're not just reaching out to employers, they're also reaching out to employees to ensure that employees understand what their rights are. And you certainly want to stay ahead of your employees. So you want to ensure that as an employer, you know what your obligations are. So let's get into that. The Act generally prohibits an employer from paying an employee who is a member of a protected class, and there are a number, as you know, from the New Jersey law against discrimination. There are a number of protected classes, and you cannot pay an individual who's a member of a protected class less than what it pays an employee who is not a member of that protected class. Now, another important distinction, because, and as I touched upon, but I didn't talk about specifically, you know, we've got a federal law that has been in place, an equal pay law that's enforced by the Equal Employment Opportunity Commission and the federal courts. And it's important to take a look at the New Jersey law as it compares to the federal law. And what you'll find is the New Jersey law is indeed more aggressive and therefore requires more attention. One of the areas where it's more aggressive is in the analysis of the work that one employee is doing compared to another employee. The key phrase is substantially similar work. So not exactly the same work, but substantially similar work. The New Jersey Act is stronger than that federal counterpart, the Federal Equal Pay Act. It only covers gender-based pay disparities and requires equal work. So federal talks about gender job-based disparities. State law, the New Jersey Equal Pay Law, covers all of the protected classifications, and we'll get into the details of what those classifications are shortly. So we're looking at a stronger law in terms of who it's applicable to, but also in terms of how it's going to be analyzed. So federal says, hey, if somebody's going to complain that another individual is getting paid more, they're going to have to show that they're doing equal work, a more challenging standard for the complainants. Under the New Jersey law, it's just substantially similar work. Now, of course, how do you define that? Well, we will get into a little more detail about that. But again, when we talk about doing an internal audit, you're going to want to try to attack those criteria and get into an analysis of what the work of each employee does. So if you don't have job descriptions, you sure as heck want to make sure you develop and follow them now, because that's where your comparisons are going to begin. They're not going to end there, but that's where they're going to begin. So when we look at the New Jersey Equal Pay Law, again, we're going to be looking at the New Jersey law against discrimination. And indeed, we're going to take a look at the protected classes. And you have race, creed, color, national origin, ancestry, age, marital status, civil union status, domestic partnership, affectional or sexual identity orientation, genetic information, pregnancy or breastfeeding, sex, gender, disability. Then we go on to atypical, hereditary, cellular, or blood trait, service in the U.S. Armed Forces, nationality, genetic testing refusal, or refusal to disclose information with regard to genetic testing. So there you have 19 identified protected classes that you have to keep in mind. And as you take a look at your employees, you need to be aware of their membership in a protected class. And then you need to take a look at the jobs that they do and compare it to those doing the same jobs, and ensure that you don't have disparities that cannot be substantiated or justified for the business reasons that we'll be talking about. Education and enforcement, again, that's what the division is really focused on. And it, of course, was created by the New Jersey State Legislature a number of years ago to indeed monitor the laws that were being adopted by the legislature, to educate the public about those laws, and then to administratively enforce those laws. But as I touched upon, while enforcing NJLAD and enforcing the Diane B. Allen Equal Pay Act, it also shares that role with the New Jersey State Superior Court. So a person who feels that they've been aggrieved under the New Jersey Law Against Discrimination or the Pay Act can indeed file a complaint with the New Jersey State Superior Court. And the objective, again, as your objective should be, is to prevent and eliminate discrimination in the state of New Jersey, and certainly in terms of compensation. And by the way, I keep using the word compensation, but I'm also referring within that reference to benefits. So you cannot discriminate in terms of benefits. It must be consistent. It must be based upon non-discriminatory, non-illegally discriminatory criteria. So the question is, do gaps still exist in New Jersey? And I'm going to take us back to 2018. And in 2018, the U.S. Labor Bureau found that indeed women earned 81.3% as much as their male counterparts. So you certainly saw a gap right there. Black women, in fact, nationwide, earned only 80% as much as white women, and only 65% as much as white males. Hispanic women earned only 76% as much as white women nationwide, and only 62% as much as white men. So the New Jersey Equal Pay Act seeks to further reduce those gaps.
Hey, Tom, I have a question.
Yeah.
So the question is, can a department head that oversees 4 people and has night meetings be compared to another department head that oversees 1 employee and also has multiple night meetings, one being male, one being female?
Well, I wish I could give you a black and white answer or a simple answer on those questions, but it does become very fact sensitive. And it just requires us as employers to be reasonable in evaluating the different responsibilities. So I think what you would need to do is provide the business justification for a distinction between the roles that those individuals play. And I think you were saying that the supervisory responsibilities of overseas employees may require some different schedule commitments, and that indeed may be a distinction that can be recognized and compensated. But let's carry through what we have here and see if we provide you with some additional information. But before I show you the way out, I just want everybody to understand what happens when we get dragged into a situation where we have an allegation of discriminatory pay disparity, and again, illegal discrimination, expanding the remedies for pay discrimination. Well, the New Jersey law against discrimination limited exposure to back pay awards to 2 years. Now, under the Equal Pay Act, it creates, although the statute of limitations of 2 years still exists, it allows for a look back of 6 years. So in other words, if an individual can establish that they've been subjected to pay discrimination within the last 2 years, then in terms of their damages, they can get an award of damages that goes back a total of 6 years. And that could be a significant financial difference as to what was previously available to them. So the change in the term of remedies is something to be aware of. And certainly the consequences is more severe. As I note here in this slide, the discrimination must be continuous. In other words, it must have continued to occur all the way back over the course of those 7 years. And the incident complained of has to be within 2 years of filing the complaint. Now understand that the issuance of a paycheck could be the most recent incident if that paycheck is evidence of an illegally discriminatory compensation. So the most recent violation occurs within 2 years, but if it's continuous, it can go back as far as 6 years. Equal pay for substantially similar work. Again, get a little nervous about that comparison. And when I think back to the Supreme Court Justice Stewart when he was trying to define what obscenity was. He made that infamous comment that, well, I know it when I see it. Well, I do get concerned sometimes, and the question that was presented by John earlier raises that concern, that a trier of fact, be it an investigator from the Division of Civil Rights or a judge from the Superior Court, or for that matter, potentially a jury in a superior court of law may have to see these things and hear these things before we know whether they're acceptable under the standard of substantially similar or substantially different work. I do want to take a look specifically at the subsection of the law, subsection T. It prohibits an employer from paying an employee who is a member of a protected class at a rate of compensation, including benefits, which is less than the rate paid by the employer to employees who are not members of the protected class for substantially similar work when viewed as a composite. Now, again, John, here are some reference points for your question. Substantially similar work when viewed as a composite of skill, effort, and responsibility. So the distinction between roles, the distinction between work, can it be articulated in terms of the skills that are required or the effort that is required and or the responsibilities that are being assumed? Pretty challenging to make that distinction sometimes. If a protected employee demonstrates that they are compensated less for, again, there it is, substantially similar work, the burden shifts to the employer. Now, this is where it's going to you now. It shifts to the employer to show that, and let's go through these now. The pay differential is made pursuant to a seniority system and or a merit system. Okay, so that's one exclusion. Now, a bona fide merit seniority system would include, Steve talked a lot about civil service already, and civil service is a bona fide merit seniority system compensation scheme and schedule. So therefore, it wouldn't apply to those employees who are covered by the civil service guides. Also, it recognizes compensation that is set forth in union contracts, so in your collective bargaining agreement. Again, as long as your collective bargaining agreement cannot be shown to be discriminatory. However, generally a salary guide that's provided for under a collective bargaining agreement or a compensation scheme provided for under a collective bargaining agreement is going to pass muster of this number one exception, a bona fide merit seniority system. So there's one. Next, number two, that all five of the following are true. So let's get into that and really make note of that as you consider some of the positions that you have within your organization. Pay differential based on legitimate bona fide factors such as, again, here are some criteria to reference. Reference it, hopefully, while you're doing that internal audit, that internal evaluation, because you're going to be referencing it if a complaint is filed against you and you've got a Division on Civil Rights investigator sitting across from you. So the factors can include training. So there's a distinction in the training that a person has. Education. There's a bona fide difference in the level of education that is required for the positions. The level of experience, quantity or quality of production in terms of what the individual produces in their particular positions. Now, it has to be demonstrated that the factors are not based on sex or any other protected characteristic. Next, we see, let me just see what I've got here. Next, we see that each factor is applied reasonably. So I go back to my earlier comment. You have to make sure when you start distinguishing between one position and another position that the analysis, again, has a sound business basis, and it is indeed reasonable. One or more of the factors account for the entire wage differential. That's a viable defense. Next, the factors are job related based on legitimate business needs, and I've been alluding to those words, those phrases, a number of times throughout the presentation this morning. Job related, legitimate business needs. In other words, you can't justify a distinction by coming up with some characteristic of one particular individual who happens to be outside of the protected class, when that characteristic may have nothing to do with the job responsibilities the persons have. So it really needs to be indeed job related. So employers, as I touched upon earlier, employers may not reduce anyone's compensation in an effort to cure a violation of the act. So when you get a complaint and you take a look at the situation, you can't have that knee-jerk reaction of, well, okay, in order to avoid the liability here, or even to avoid my having to defend myself in this situation, I'm going to lower that person's salary to where you are. Specifically prohibited under the law. You know, another thing that I suspect you are all very familiar with in terms of the New Jersey law against discrimination, as well as other state and federal laws, the Conscientious Employee Protection Act, age discrimination laws, both state and federal. You can't retaliate against a person who files a complaint. But I also want to emphasize that the Equal Pay Act, the New Jersey Equal Pay Act, goes beyond that. You cannot retaliate against a person who starts looking into compensation within the organization, that requests information with regard to compensation within the organization. You know, there was a time in history, as many of you may recall, where what a person made was pretty sacrosanct. You didn't talk about it. You didn't talk to family. You didn't talk to friends. You never knew what your father made. You never knew what your mother made. You never knew what your colleagues made. Well, that's not the case any longer. And in fact, trying to enforce such confidentiality is going to put you in the crosshairs of the Equal Pay Act. It's important to understand that you can't retaliate against a person who starts inquiring into the characteristics of compensation within your organization. A person who consults with an attorney, again, these individuals cannot be retaliated against for doing that. A person who is outspoken against discriminatory practices, as I mentioned, a person who files a complaint, or those folks who, in an administrative hearing or in a court of law, testifies or assists an individual who believes themselves to be a victim of pay discrimination or other forms of discrimination. You cannot retaliate against those individuals. As I said, a person who seeks legal advice is not someone that can be retaliated against, or a person who shares information with their legal counsel or with government. And in fact, an employee requesting, as I touched upon, discussing or disclosing information related to job title or compensation or characteristics, they cannot be retaliated against. I talked earlier about the expansion of remedies in terms of the time period, extending it from a 2 years to a 6-year look back. And I also want to go over what type of remedies we're talking about. Any employee who establishes a violation of the law against discrimination, well, they may pursue and they may receive. And again, this applies to the New Jersey law against discrimination, and therefore also to the Equal Pay Act, the New Jersey Equal Pay Act. They can receive a cease and desist order, which would direct an employer to cease and desist in illegally discriminatory pay practices. Number two, lost wages and benefits. They can seek to recoup those wages that they've been deprived of over possibly up to 6 years, if indeed they can demonstrate that the pay discrimination goes back that far, but not just wages. Sorry to be a broken record, but also benefits. So if somebody's getting different benefits than other employees, there needs to be a non-discriminatory basis for that. And certainly, particularly in public employment, there are bases for it. There are standard vacation awards in terms of based upon a number of years of service. That is permissible. That's not illegally discriminatory. So those types of benefits can be awarded based upon non-illegal discrimination basis. If an employee has been terminated because of their complaints about pay disparity, or for that matter, any other form of discrimination under the New Jersey law against discrimination, they can earn their reinstatement, rehiring. They can indeed, through the Division on Civil Rights and or through a court of law, receive a promotion. The employer can be directed to promote that individual. And as we touched upon, they can receive back pay. Notice they also can receive interest on those funds that they're awarded. The damage of emotional distress is also available through a complaint under the Equal Pay Act. And reasonable attorney's fees can be awarded. And that, needless to say, can be pretty sobering when you think you have to pay your own attorney, and then you have to pay, indeed, the plaintiff's attorney or the complainant's attorney. So you're looking at some very significant damages under not only the New Jersey law against discrimination, but even more aggressively awarding such damages under the New Jersey Equal Pay Act. And then also something that includes out-of-pocket expenses, whether it's costs of litigation such as depositions, filing fees, and what have you, but out-of-pocket expenses can also be awarded. Then, of course, that what can be a very large basket of damages, if indeed a trier of fact is satisfied that the conduct engaged in, the discriminatory conduct engaged in, was knowing and malicious, then punitive damages can be awarded in a superior court action. So you're not going to see the Division on Civil Rights going to that level of damage award, but you will see that available to a state superior court. So the Division on Civil Rights may also order, in terms of their administrative authority, they can impose fines on top of this. If I haven't scared you yet, gee, I'm surprised, because I am trying to be complete with what the exposure is, so that when you're exasperated dealing with your employment attorney, I'm at least saving him or her from having to tell you about this for the first time. On top of all of that, what I just described, there are also fines that can be imposed by the Division on Civil Rights, and up to $10,000 can be imposed for a violation of the Equal Pay Act, up to $25,000 for the second violation of the Equal Pay Act within 5 years, and up to $50,000 for a third and subsequent violation within a 7-year period. So there you're talking, about fines on top of direct damages that can be awarded to the employee. $10,000, $25,000, $50,000 in penalties. So it's really important to be aware of that. And under the, the New Jersey Equal Pay Act, here it comes. It's the issue of trebling. And those of you who are familiar with the New Jersey Consumer Fraud Act, you're familiar, therefore, with this concept of trebling. It's essentially 3 times. Take the damages and times it by 3. So in terms of trebling in the Superior Court, it's required of a judge. The judge has to treble damages. At the DCR, the director may award trebling of damages, 3 times the established damages. So keep that in mind. So sobering and just financially devastating for employers. Okay, so that's all the prep work to get you to really pay attention at this point, and I have no doubt that you are. So, what should an employer do? Well, actually, John stole the thunder of this at the very outset. What should an employer do if you haven't done it already? You really got to get to it this afternoon. Once you go back and look to see if you're paying out sick leave to employees who were hired after 2010. This is your second assignment, because this really, well, you'll be serving your employer well by auditing, and it is an internal audit. It's not an external audit, it's an internal audit. This law is focused on pay practices within your organization, not pay practices compared to other organizations outside. It's internal compensation practices. So what should the employer do? Well, the employer should do some self-evaluation. And you really want to take a look at your compensation practices before you have to deal with a complaint, because you will have time, as again was touched upon earlier, you'll have time to take remedial steps to correct what may be perceived as illegal pay disparities. You'll have time and opportunity to correct it. You want to get out in front of this problem if you determine there indeed is a problem. So don't wait for a complaint. You want to identify and address any possible pay disparities. And you want to make sure you've done a thorough Equal Pay Act self-evaluation. So what's that going to involve? And again, I strongly recommend you go to the Division on Civil Rights website. They do an outstanding job in terms of assisting public employers with guidance on the Equal Pay Act, its applicability, but also in terms of actual forms that you can use for internal evaluation. They have a basic guide to self-evaluations for public sector employers, and it's really very helpful. And it talks about more of the criteria that you can take into consideration: gender, age, or birth year, race, ethnicity, primary work location as a distinguishing factor, possibly. Work type, of course. Are we comparing part-time and full-time employees? Well, we want to compare full-time to full-time. We want to compare part-time to part-time. We want to compare temporary to temporary. By the way, it applies to all of those classifications. It does not just apply to full-time employees. It applies also to your part-time employees. And amongst part-time employees, are there pay disparities that could raise issues of discrimination? Temporary employees, are there pay disparities that could raise issues of discrimination? And as you do this evaluation, of course, you're going to look at exempt and non-exempt status. You're going to take a look at dates of hires. You're going to take a look at the job titles, those job descriptions, job duties performed, the job codes, if you have any that are applicable, range and bands, date and most recent job code range band, divisions and unit scopes, and it goes on for literally another 13 criteria. But as I said, the basic guide to self-evaluations for public sector employers is available on the New Jersey Civil Service Commission website and on the Division on Civil Rights website. The Civil Service Commission also actually provides on its website compensation worksheet forms for no-range titles. So it's a very helpful format to utilize, and I would urge you to go to Civil Service's website and to the Division on Civil Rights website for those very helpful resources. Now, in terms of this self-evaluation that you're all going to do, well, step one is to gather the relevant information. Step two is to identify comparable jobs and the folks that are in those jobs, and to see if the pay is either comparable or equal, or indeed there are justifications for the disparity. Number three, make sure you calculate salaries and identify membership in one or more protected class. Step four of your process is going to be to access or to assess whether differences in pay are justified under the Equal Pay Act. Can you justify the differences in pay? And then step five, well, you're going to want to remediate any pay disparities that you find. And more broadly, you're going to want to adjust what your compensation practices have been. So through this process, you're really going to be joining indeed the state legislature and the state of New Jersey in working toward eliminating pay disparities resulting from gender discrimination or any discrimination based upon a protected class. So, again, I think as we had with the earlier presentation, I've stayed well within my time, but it does offer an opportunity to present our two polling questions. At least, John, I think you have the two polling questions that we can perhaps put out there, but also open it up to questions with the understanding there, of course, is such a fact-sensitive analysis that you have to go through. So the first question, has your company ever audited its payroll practices to identify possible pay discrepancies? So we would ask you to comment on that. And have you looked at pay discrepancies between men and women, between other members of protected class? Both? Or nope, none, never, nada. And then if you just submit.
So Tom, while we're waiting for that feedback, I actually had one instance. I was working on a job where a town, the mayor's campaign manager was hired after the campaign, after he won, put him in a position and realized that he didn't like what he was doing, didn't like the job, never adjusted his pay, put him down with a different group of employees, all who were paid, all women. This guy was a male, all women, all paid significantly less than this person. And the rumbling started, and it was a civil service community. So we went in and did an evaluation of titles and trying to fix the parity issues. Cost the town a lot of money for the mayor's, what he decided to do. That was one that took a little bit of time, a little bit of investigation to figure out how we resolve it. And especially in the civil service system, it's not just an immediate fix. It took time to get them back up. And the town's position is that we took proactive measures to resolve the issue. We identified it, and we were working towards making that equal, or as equal as we could make it.
And I think that argument is going to carry certainly weight with the Division on Civil Rights and their investigation. The problem with this law is that the discrimination does not have to be intentional. The employer does not even have to realize that they're discriminating, but the facts will speak for themselves. And as I indicated earlier, civil service actually does provide some protection because it does offer, at least for the salary range positions, that's a bona fide merit merit formula. So that provides some help there. But it's interesting, and I jump over to our results from the polling question. Has anyone done such evaluations? Well, the vast majority have not, and I'm not surprised by that. 63%, 6% have at least looked at some disparities, or to ensure that disparities don't exist between men and women in their organization. 25%, I mean, that's certainly encouraging and impressive. 25% have done both. But it's the folks, of course, those of us that are answering never, that we really want to go back and take a look at this. This really has to become a priority for you, for all of the reasons. We just spent a half an hour talking about the exposure that exists. And again, as we come out of COVID, I mean, it was just the timing of the law. This law is adopted in 2018. Not too far off into the future, we end up with COVID-19, which puts new priorities in front of the state. Well, I think we're going to see the Murphy administration refocusing through its Division on Civil Rights and through the Civil Service Commission on these issues of discrimination and disparities. So it's going to be important to self-evaluate before they evaluate for us. Perhaps we can go to the second poll question. Did your company employ wage freezes or wage reductions this past year in response to the pandemic? And of course, those that are civil service communities, that would have been a different ball of wax. And by the way, those of you who prefer to subject themselves to true pain and punishment, the full text of the Diane B. Allen Equal Pay Act is also available on the Division of Civil Rights website. It's also going to be available. All of this information is available on Laddie Clark and Ryan's website, and in reference to this program, and the details referenced in this program will be available on that website at lcrlaw.com. So you certainly can reference it there. And the answer is, did your company employ wage freezes, wage reductions this past year in response to the pandemic? 24% answered yes, 67% answered no. So of course, again, it's were the wage reductions or the wage freezes implemented in a non-discriminatory fashion? And were you conscious of those issues in evaluating how the wages were going to be adjusted? I think back to when I was a kid, and okay, that was maybe a half a century ago, pretty scary. But I still remember my father worked in a manufacturing company, and he was a a supervisor, and the company had to go through some layoffs. And he would come home and he'd talk about it, and he'd go through the criteria as to who would be laid off. And one of the criteria would be, well, okay, if it's a married man, well, then he's not going to be laid off. But well, that woman, well, she probably has a husband who has another job. So that was done. It was just done on a regular basis, and it was done openly. And I think we all recognize that was another world. And we really have to focus on the current world that we're in. And, the improvements that we have made in society as well as in the workplace. And be very careful in consciously evaluating things such as pay, compensation, and benefits. Questions? Are there any additional questions that I can struggle to answer, or for that matter, if I'm sure folks have been able to think through Steve's presentation, and I'm going to throw Steve under the bus as well, and open him up for some additional questions if there are any. So, John, we're ready for questions if we have any.
I think you scared the crap out of all of them.
Yeah.
No questions.
Everybody's speechless at this point.
Well, if that's the case, can one panelist ask a question of another?
I don't think the Division on Civil Rights permits that, but I'll have to take a look.
All right.
But yeah, sure, go ahead.
The question I was going to ask for the guidance of everybody, it's a 6-year statute of limitations. So if you find a problem due to what kind of problem today, and you fix it and remedy it, how do you avoid, and what can you do to avoid having a plaintiff saying, thank you, you just admitted a violation for the past 6 years, I want a retroactive remedy?
Well, first, Steve, and I think I misspoke when I referred to it. It's not a 6-year statute of limitations. It still is a 2-year statute of limitations, but it provides a 6-year look back in terms of quantifying damages for the complainant. And you raise a very good question. And unfortunately, the answer is not absolute. In other words, if you do correct it, the individual, if there was a discriminatory act within 2 years, even if you've corrected it, that individual may be able to file a complaint and get damages that go back for 6 years if they can show that the discrimination has been occurring for those 6 years and it's been continuous. So the way to address this is indeed correct the disparity, and that will start your statute of limitations clock running of 2 years. And if you've corrected the disparity, well, and you're over 2 years out, then you've survived the statute of limitations.
Would it also be important to, in that case, provide a remedy going back 6 years and making sure you cover 6 years of discrepancy as a way of, if not cutting off liability, making a lawsuit less financially attractive?
That certainly would be a financial analysis that you would want to do with your CFO and with your municipal attorney. So yes, that would be a very serious consideration. Any additional questions?
The last one was just, are you going to make the PowerPoint available?
Yes, the PowerPoint will be available on lcrlaw.com.
Okay. I see no other questions right now. So seeing no questions, actually, Tom, thank you very much, both Tom and Steve. We appreciate all your wealth of knowledge and the topics.
Well, I really appreciate Nisivoccia giving us this opportunity and to be with this terrific group and to discuss these very important issues that continue to keep us up at night. So thanks very much.
Thanks, Tom. Thanks, Steve.
Just a reminder, there will be a survey after the session is ended. If everyone can please just answer that, it'll pop up automatically. And a recording of the presentation and the slides will also be available through email.
Right, and we're also planning another CMFO roundtable related to the American Rescue Plan Act. We don't have a date yet, but we're trying to line up a speaker with some of the information that was just recently released.
During this session, the division, they sent out an egg notice saying that they will have information forthcoming soon on guidance.
Okay. Well, thanks everyone for participating. Really appreciate Tom and Steve, your guys' presentation, and John and Brian, thanks again.